Hey, good morning, everyone in business law. I'm going to put up a quick chapter review for 19 dealing with warranties, um, product liability, and consumer protection. It's a big chapter. A lot of important information comes in through this chapter, and it's something I can't understate about its importance because it's about when you get either goods or services and they don't live up to either an overt assurance, an express warranty, or an implied assurance. It doesn't meet minimum standards that we expect as a society, and therefore you may have a lawsuit. And there's different kinds of warranties that are implied, and there's different kinds of warranties that are express. But what is a warranty? It's an assurance, a guarantee that the product or services will live up to a certain measurable standard. Um, those are easy. The express warranties are the easy ones. You have 2 years, any defect in workmanship, parts, things of that nature. If something breaks down in 2 years, you're covered. That's a express warranty. A full warranty is that they will not only consider, say a full warranty for 3 years. That means all parts, all labor, everything's included. And if they can't make it good through repairs in a reasonable amount of attempts, they will give you a free refund of your money because it's a product they can't repair. Full warranties are rare. Most are limited warranties in that they're both limited in time, but they're also limited in terms of either just the parts but not the labor, or they're only warranting certain aspects of the product and not all of them. Because to give a full warranty is very, very dangerous because you're on the hook for a long time after you've already sold the product. The federal government has created the Magnuson Act, which we'll get to near the end of the chapter, but there are certain rules about these express warranties that must be complied with in order to meet that standard of law. If it's goods over $15, they have to meet certain implied, basically, they didn't have to be written out. The government's going to impose certain warranty qualities on all products given to consumers over $15. Seller's opinion, generally speaking, seller's opinions are not actionable. Things like this is the finest wrench you'll own, or this is the finest tool set, or this is the best value. Those are the kinds of things that, because they're not measurable in an objective fashion, they can't be held accountable for them. The only time they can be is if the seller's an expert and the buyer has no knowledge about the topic. Then you can sue if the opinion turns out to be a falsehood, it's almost like a type of fraud, but it's very rare to be able to sue over a seller's opinion. Things like, it's usually called puffing or sales talk, not actionable. Best on the market, great neighborhood, things like that are not actionable. But unless they are an expert, so I'm going in to buy a certain kind of boiler for my house, for example, I know nothing about boilers, and I talk to an expert and they tell me in their opinion, this is the one that's going to work best for your home, and it turns out not to be true, that might be actionable, but it's very rare and it's very difficult to prove. Now, implied warranties are just that. No one spoke about them. They weren't overtly made by the seller, but the law is going to impose them. That's an implied warranty. We'll get to those in a second what they are. We were talking about full or limited. So all sellers, meaning merchants or non-merchants, casual sellers as well, all make the following warranties. First one's warranty of title. They have the power to confer title, whether they're the owner of the goods or they possess them on a consignment. They have the power to transfer title. So say I buy something from you, bicycle or road bicycle, and I'm using it and I enter into some kind of contest and somebody sees the bike and says, hey, that looks just like my Cannondale I used to have that got stolen out of my barn. And they look at it and say for whatever reason they kept their serial number of the bike, and sure enough it matches up. It's their bike. They have the right to get that bike back. We know thieves generally can't transfer valid title. Fraudulent conveyances sometimes can convey good title to a good faith purchaser, but not outright thievery. So the thief has conveyed the bicycle to me, and now the true owner has the right to get it back. They get it back. What are my rights? I can sue the seller, but what if the seller was kind of innocent? They actually had bought it at a sale, a yard sale or something like that from the thief. Can I sue the innocent seller? Yes, I can, because they breached the warranty of title. They didn't have valid title, even though they innocently didn't know that. They weren't necessarily a conduit through which a crime was conditioned. But because I'm out the bike, now I can sue for breach of warranty for title. The next one that all sellers make is the warranty against encumbrances. This is similar. So you're selling me a car, Well, it's easy with a car. You'll see right in the title document whether there's a lien on it or not. So that's not a very good example. But an example that came up in a business transaction I was a little bit involved in, somebody bought a pizza, a little restaurant from a seller. They also bought all the fixtures with that sale, meaning there was ovens and other, I think there were meat slicing machines, a lot of different equipment in there that they bought with the sale of the building. Well, lo and behold, within a few months, somebody comes in from some company that says, there's tens of thousands of dollars still owed on these very large ovens in the back. We haven't had a payment for a while. We're going to have to repossess them. My client, the buyer, says, wait a minute, I bought this from, Luigi's or whatever. He goes, well, our contract's with Luigi's, but we have a security interest in it. It's infringed. There's a lien on it. So we did contact the seller, and the seller did make good on that. And with the proceeds of the sale, they meant to do it anyways, but they should have done it before the inception, or should have told my client that there was a lien, because you can do that. You can sell subject to lien, just like somebody might buy a car from somebody. They say, I still owe 2 years of payments on it. So you can buy subject to the encumbrance if you want to, but you have to be told of it, because otherwise it's a breach of the warranty against infringement. Makes common sense. When you buy something, you want to have not only clear title, but you want to have no lien or encumbrances, because it affects title. The next one, warranty conformity to description, sample, or model. It's kind of like if you go into a friend of mine, an attorney, and I, the first time I ever bought a suit like this, we went in and we actually looked at swaths of clothing, and they put it over your arm and like, well, how do you like the feel, the look, and the color, and all that stuff. And that's great. And goes, yeah, I'd like to buy a suit now. And they would tell you the price would be, and then what should the suit show up as? 2 or 3 weeks later, after it's all tailored out, it should be made out of the same exact material that they gave us as an example, or a model, or a description. You can't give. I always think of these things. You don't see them too much anymore. But when I was younger, I go to the mall. There'd be these kiosks set up around the holiday season where they'd be selling these like remote control airplanes and helicopters and cars. And there'd be some guy demonstrating. And they'd be really, really awesome. And you say, okay, geez, it's $25. I'll buy one for the kid, And so I buy one for my kid, or 2 for my kids, or 3 or 4. I have a bunch of kids, so I'm going to buy these things. And all of a sudden, I'm skeptical, because I'm wondering, is the car he's using, or the little helicopter he's flying around, representative of what I'm actually going to buy in the box? Well, it has to be, because the law is going to imply that the model they're demonstrating is equal to, in terms of quality and performance and abilities, just as the one in the box. The problem with those kiosk things in the mall is right after the holiday season, they tend to be gone. So good luck enforcing your implied warranty. And the warranty is what? It meets the description, model, or sample that was presented. It's kind of common sense. Nothing worse. It was a film I used to show on the old brick and mortar class, and I can't find it anywhere online. Actually, it was a VHS tape, and this guy's watching TV at night, and he doesn't know how to cook, and he's got his first apartment, and he sees there's somebody selling these knives, with real beechwood handles and stainless steel blades, and they never get dull, and it comes with a beautiful hardwood cutting board and all these different things. And then when he gets it in the mail, the handles are made out of plastic. The steel is not 440 grade stainless steel, and the board is actually a plastic, imitation of a wood cutting board, really cheap imitation. So what did the product not live up to? It was an infringement of the implied warranty of conformity with sample, model, or description. Kind of common sense. This next one's a big one. This only happens if certain elements happen first, though, and it's called the warranty of fitness for a particular purpose. So say I go into a paint store, and the seller recognizes what I'm saying is that I'm ignorant about what kind of paint to use. Say this happened, I used to paint for a living with a painter friend of mine. Matter of fact, his picture's right behind me. He croaked last year. One of my best friends, but when I was a kid, I worked for him. And he was very knowledgeable about paint, but he taught me how to paint, but it was a long learning experience about the different kinds of paint, how they applied to different surfaces and things like that. And I remember going into the store, and I used to go to a very specific one because I trust them to provide me with a paint that was fit for a particular purpose. So sometimes I was painting plaster, raw plaster, never had paint on it before, and I wanted to know what kind of primer I should use, or if a primer was necessary, all these kinds of things. The seller knows relying upon their expertise. The expertise of the seller is to pick the product, and it must be what? fit for the purpose it was intended. So if the guy, say I'm painting wrought iron outside, a walkway, there's stairs going down and there's these wrought iron handles that go down, and they gave me a really cheap latex that does not adhere well to wrought iron, even though I asked them I need a paint that will do well on a rusted wrought iron guardrail that I want to be able to coat in one surface, and he gives me a latex paint. He probably should give me an oil-based paint or something else. And he gave me, something that was flat. He should give me something that was a satin or a semi-gloss or something like that. It wasn't fit for the purpose for which it was intended. That's an example. Another example is, say I want to start taking up welding. I go into a shop where they sell, I need to be protected. So I said, hey, I'm doing this kind of welding. I want goggles that protect my eyes, not only from flying little particles, but also from the bright flashes of arc welding. What kind of goggles should I get? And the seller says, these are the kind you want for that kind of welding to protect your eyes, not only from particles in the air, but also from the large intensity of light. This will protect your eyes. And if it doesn't, I can sue for breach of what? It wasn't fit for the specific purpose it was intended. The seller knew what I was going to use it for. They relied upon their expertise, and they know I was going to rely on their decision making in picking the product. And it comes up. It just came up recently with me about a chisel. I used to have lots of tools. I've moved so many times in the past 10 years. I feel like a transient human being. But I don't know why I lose all my stuff. And then later, when you're looking for something else, you find the stuff you're looking for. But it seems like all my tools are haphazardly all over the place. And not unfortunately, but my most recent home that I moved from, my son bought. And so when you leave a home that your kind of family still owns, tend to leave a lot of crap behind because you don't feel like the urgency to get rid of it. So every so often I'll stop by and see my son and say, hey, look, I can go to your house and live. I think half my stuff is still down in the basement. And it is. And that's where some of it is. And but my point is I needed a chisel. There's a concrete pad behind my house, and I have like a shed that I was putting there, but I want to use the ramp, but there's this hump in the concrete for the footings. It doesn't matter, but I needed to remove some of that concrete to make it more level. And one way I could do it was with a grinder, but I thought that'd be too messy and too hard. So I'll just get a good masonry chisel. I wouldn't be able to spot a masonry chisel as opposed to a wood chisel. So I went into the store and I said to the clerk, I said, I'm looking for, I think it's called a masonry chisel. And she said, yes, we have masonry chisels. And she was really good about it too. She goes, what are you using it for? She goes, well, I'm going to take a hammer and hit the back of the chisel, and I'm going to chip out a 3-foot section that's only 2 inches high, but I need that 2 inches over a 3-foot section chiseled down to be level with the grade of the ground. And so I want to break it up a little bit. He goes, this is the kind of chisel you want. And even if it didn't say it, when you handed me a chisel, set it right on it for masonry concrete work. So she was correct. But what if it didn't say anything? I went back and I'm starting to bang against the chisel and I'm banging against the concrete, and the blade just starts bending. It doesn't, it's not hardened enough for it, because really the chisel was designed for wood or for, carving plastic or something, or chipping paint off a wall. It was really a scraper, not a chisel at all. I could sue if they weren't willing to work with me. I could sue for breach of the warranty, that it wasn't fit for the purpose for which it was intended. Another example, just to tell you real quick, and I try not to make these videos too long, but going back to my friend Stanley, the guy I painted with, pretty smart guy. He wasn't educated in law, but he loved law and he liked to talk to me about it. In my old office down in Southbridge, Massachusetts, he helped me paint. I ended up buying the building and I was refurbishing it all. And there was a lot of plaster work and stuff, and he did a lot of painting. He was a great painter. And then I came back from court one day and I hear him screaming and swearing in Polish. He was fluent in Polish swears, and I know them because I spent a lot of time with him growing up. And I'm like, what's happened? Why is he upset? And I come up the top of the stairs and he's covered in paint, green paint. That was for the trim along the boards. And it's all over the floor. He always was very conscious. So he dropped cloths everywhere. So the building wasn't screwed up so much, but he was covered in paint. And he was so upset. And he goes, we've got to sue that paint store for breach of warranty. And right away says, what did they breach? And he said, did the can just explode on you? And he said, he's a very short gentleman, and he says, I was standing on the can so you get up to the molding up around the edge of around the door frame, and the whole can just imploded. And I've never had that happen to me before in 60 years of painting. All I can remember was, oh, so the can wasn't fit for the purpose it was intended for. He goes, exactly. He goes, cans of paint, I said to him, are intended to hold paint. They are not intended to hold people up. And in case there's an ambiguity, guess what had it right on the label? It's one of my favorites showing them. There's one area that the paint didn't cover. There's a picture of a person standing on the paint can with a circle around it and a line through it, like do not stand on it. And there's a big bold print, do not stand on these cans, because the cans have changed over the years. They're oftentimes now plastic on the bottom, and even the sidewalls are sometimes plastic. They just don't have the durability for using things like standing on it. So it was not only not a breach of the warranty for the intended purpose, because the intended purpose was the whole paint. It wasn't used to put a person, elevate them up about a foot. And secondly, there was a direct what? There was a direct waiver or surrender of any implicit warranty that's what the purpose was for, and the paint can was to stand on. And you'll sometimes see that with buckets. You buy buckets and stick here. You'll have a symbol that don't stand on, things like that, because they're trying to avoid anybody trying to suggest that it wasn't fit for the purpose for which it was intended. A lot of people think buckets are for standing on. They're not. Additional warranties of a merchant. Now, this only applies to merchants. What is a merchant? Person who, in a regular course of business, sells goods on a sort of a regular basis. It could be seasonal, but that's their business. Not casual. It's not a tag sale you're doing once in a blue moon. The big one on this one is the warranty against infringement. It's not. I shouldn't say it's a big one, but it's distinct to merchants. So, say I bought a computer, and it turns out the computer has stolen its operating system from Microsoft or from Apple or something like that, and I get a cease and desist letter. Well, would I actually potentially be banned from using the computer if it's using stolen trademark or patent information? Yeah. And so now I have my computer and I spent $2,000 on it. Could I sue the merchant for breach of a warranty against infringement? Infringements are related to things like patent and intellectual processes and things like that. Yeah, absolutely. Don't come up that much, but it's important to know. The next one is really, really the big one that we all sue over. I shouldn't say sue over, getting controversies over. It's with the warranty of fitness for a particular purpose. It's called merchantability. Merchantability just means it's supposed to work. It doesn't have to work perfectly, but it's supposed to work. But for how long? Say I bought a washing machine and it said, comes with no warranties, as is, where is. Now, when it says as is, that means I'm waiving all warranties. There's not even this implied warranty. But let's assume they don't say as is, but they don't give any express warranties. There's no 2-year warranty on parts and labor, none of that. It's just they're silent as to any kind of warranty. And there's no waiver of implied warranties. So what implied warranty is if you buy a washing machine? It washes my clothes. But for how long before it breaks down? So say I bring it home, a second week of using it. I'm not abusing it. I'm not putting giant horse blankets in it or something like that. I'm just using regular light clothes. I'm following instructions on how to use a washer. And all of a sudden during the spin cycle, that column that's on it's on some kind of a bearing, the bearing breaks. Brand new. I had it for a month. Is that a breach of the warranty for merchantability, that it failed to work as it should for a reasonable period of time? Probably. The problem is how long do we go out? Because it's implied. It's not 9 months, 10 years, 3 days. It's a reasonable period of time. And it's the kind of analysis that we get into when it comes to merchantability, which is the same as fitness for the purpose for which it was intended, generally, for normal use. Usually what it is if it breaks in a certain time frame that we wouldn't expect it to, just by common sense, then that's evidence that the product was probably flawed at the time you bought it. But it's a question of fact, and that's why there's a lot of suits over it, because the seller is saying, hey, you had the thing for 6 months, it was working fine, it was just worn out. And then you as a consumer say, well, washing machine shouldn't wear out in 6 months on reasonable use. It's not like I'm running a hotel or something, using the heck out of these machines, just using it casually, and it should last more than 6 months. People don't change their washing machines every 6 months, do they? And then it would have to go before the jury, and then they'd have to consider what you use and what you don't use. It's funny I bring that up because I actually did have at my son's house at a washing machine, and one of the rare times I do it because I'm not a big fan of buying those extended warranties when you're at the checkout. For another $60, you can buy an extended warranty to give it an extra year on this, because I had a year limited warranty. And I always remember, I said, this is my luck. This thing's going to break right after the year. and I'll be stuck because it says specifically there are no other warranties, and all other warranties are deemed exhausted after 1 year. And I have 4 kids, and I'm kind of a clothes washing freak. I can't wear anything more than 10 minutes without want to change and wash it. And so I go through a lot of laundry. I know I do. So I remember one of the few times I always think it's a sucker's bet to buy these extended warranties, but it does make you sleep at night, pay a little extra money if something goes wrong. I kid you not. I was washing these really heavy blankets for my kids and stuff. And I go down there and it wouldn't go through the spin cycle. Like the clothes were really wet. It would wash and agitate, but then it wouldn't spin it around. And that's why I brought up the bearing. The bearings were gone. And I remember finding the receipt. I'm usually terrible. I'm a scatterbrained person when it comes to saving stuff, but I kept it right in a little cabinet right above the washing machine. Oh, there's the receipt and everything. And it was past 1 year, but it was in the next year of the extended warranty. And they came out and fixed it, and they said the thing was completely blown, and they repaired it. And the bill came out to something like, I don't know, almost as much as the washing machine cost. I don't know why they just gave me a new washing machine, which is one of the options they could have done, but they also had a right to repair it, and they repaired it. I didn't have to pay a penny because I bought that extended warranty, and I was really happy I did it. I'll tell you what, though, it's still, my son still has it to this day, and that's 6-7 years ago. So, warranty of merchantability. It's just basically common sense. Does it work like it's supposed to do? I remember I'm thinking about eyeglasses. I got a million eyeglasses. They almost all look the same because once I got a certain style, I kind of stuck to it. But I remember one time I had a pair of eyeglasses. I just got them. I just got them from the, I was going to say from the obituary, but from the optometrist. I get glasses from the obituary. A little tired today. But I can remember wearing them. I was with my friend. I'm always taking them off and on because I can't see up close with my glasses on, and I can't see far away with them off. I guess there's something called progressive lenses. I refuse to do that. So I'm always doing this and reading over my glasses and looking like an old man because that's what I am. But I remember one time I literally had them for like 2 or 3 days. And I'm talking to my friend, and I go to take my glasses off like this, and the arm of the glass just went flying up because the screw got loose. But, I couldn't find the screw. I lost it in the grass. I was outside. I was actually golfing, and I hate golf, by the way, but I was golfing, doing something I hated. And they're broken. I'm like, what the hell? And, of course, I when I went to get the arm and try to put it back on, I ruined it. I argued. I went back there, and the guy says, well, you had a screw loose. I'm like, yeah. You gave me a pair of glasses, and I don't think after 3 days the screw should just simply fall. And he agreed, and he replaced them and fixed them, and it was great because there was a very strong argument. It violated the warranty against merchantability. It just didn't work as it should for a reasonable period of time. And again, it's debatable what it is. Sale or food or drink. This is a fun topic. A lot of people like to talk about. Food needs to be wholesome is probably the wrong word. It needs to be edible. It can't be rancid. It can't make you sick. If it does, it violates the implied warranty of consumability. Same with drink. It can't, have poison in it or ptomaine or salmonella and all those things, or it's actionable. The one thing that there is a bit of a limitation is sometimes there's naturally occurring deficiencies in certain kinds of food. And I'm thinking about seafood. So if I ordered fish, matter of fact, I just had fish the other night. It's like my favorite food. And my wife was really surprised as I'm cutting through it. I got some really large bones in the cod. She goes, oh my God, you could have choked on it. I goes, yeah, I'm careful when I eat it because I know that can happen. And she actually said, isn't that a breach of warranty? And I said, interestingly, if they gave us a product that said boneless cod fillet, then it would be a breach of a what? An express warranty, because right in the statement it said boneless. But I don't think it said that. However, is it natural that fish have bones? Is it not that uncommon to find a bone in a fish? Yeah, so if there's not an express warranty that we boneless, you usually can't sue for things that are in nature what you'd find in them. Like just yesterday, I was eating olives. I ate a lot of olives. And it was pitted olives. It said right at pitted olives, which means it's what? Express warranty, there's no pits in them. And luckily I wasn't eating like a madman like I usually did. And I was kind of slow. There was a pit in one of the olives. And if I damaged my tooth, I think there might have been a reasonable lawsuit there because it said pitted. But sometimes on some of the brands will say right on it, warning, there may be pieces of pits or pits within the olives. Caution, buyer beware kind of a thing. What are they doing? They're waiving the implied warranty or the impression of an express warranty with regard to those things. But what if you get sick from food and it turns out to be salmonella or ptomaine or some other bacterial limitation, even though the supplier of the food try to do everything right, they're usually pretty much strictly liable because food's supposed to be what? It's supposed to be wholesome. We don't have an expectation that's going to have salmonella, ptomaine. I can't think of all the other diseases and bacteria that comes with poor, spoilage of food or poor um, storage and transfer and handling of foods. But things of that nature. And I've got a million stories of my own, but also I worked with, I used to do some tort law where people would get chicken bones in a chicken sandwich. And actually in the lawsuit, the provider of the chicken sandwich said, chicken bone in a chicken sandwich is a naturally occurring state, and therefore it's not actionable. It's reasonable to find bones. And I said, the problem is it's right on your menu. It says boneless chicken patty. So there's an express warranty we were suing on, and my client supposedly developed TMJ, I think it's called, something to do with alignment or something gets affected your jaw, and it could affect a lot. It could affect your ability to sleep and all kinds of stuff. I left the law firm that I was working at the time, so I don't know what happened to the great chicken bone case, but I remember she bought the chicken bone in my office. Like, it looked like a dinosaur bone. I don't know how they got that big a bone in a chicken sandwich, but I was questioning whether or not how could that slip into the patty and no one noticed it, including, that's what their argument too was, that they're saying she must have been aware of the bone because it was so large. I don't even know if it was a chicken bone, but that's neither here nor there. Let's assume it was. Secondhand goods in most states, including Massachusetts, they are still actionable for all these implied warranties and express warranties. If given, express warranties, hey, I'm selling this used, but I'm still guaranteed it for 20,000 miles or something like that in a car. The lemon law, there's some warranties that are imposed by law outside the ones we're talking about. Massachusetts is a perfect example of the lemon law, but there's other laws like that that deal with a certain kind of automatic, legally binding warranties, whether you mention them or not. Can you exclude these warranties? Yeah, usually you say things like as is, where is, buyer does due diligence. It goes back to the old rule of caveat emptor. At one time in all of our sales, really right up into the 20th century, buyer buys something and it's defective, buyer stock, too bad. You bought a piece of crap, you got suckered. That's why it was called due diligence. You inspect it, you look at it, you make sure it works. And if it doesn't, shame on you. You didn't do your due diligence. Now we know we need to protect the consumer somewhat, so we put these implied warranties on the law standard to help consumers get some protection. But if I'm a seller of goods, especially used goods, what might I want to do? I might recognize there's wear and tear, and there may be unknown defects that I know. So when I sell those goods, I'll tell people what? As is, where is. I collect antique stuff, and I was looking for cufflinks that match another set I had, and I found them. And the seller on eBay said, as is, where is, because maybe the linkage between the cuff and the link that goes in the back might be defective after all these years. The things were made about 100 years ago. I recognize that. There'd be nothing I could do if it fell apart and parts fell off or anything like that, as long as there was no fraud. This is a little different than the lemon law, though, for example, because sometimes you can't waive all warranties. So when you sell a car as is, it still has to meet the lemon law standards, pass mass inspection for safety. How do you get around it? Well, in Massachusetts, sometimes you'll see someone selling a car parts only, or parting out. That's different than as is. That's basically just selling it for parts, so it's no expectation. They'll never have to pass mass inspection. It's up to really the buyer to bring it up to snuff if they want to. That's the way to get around that. Product liability. Caveat emptor, you need to know that Latin term, let the buyer beware. That's pretty much dead in most circumstances, except when the seller is selling things as is, where is, no warranties or promises. You'll see that in real estate a lot. The next one, product liability, what you need to know. If you get a defective product, even if it was designed well, but it turns out to be inherently dangerous, the seller is strictly liable for that. And what makes it intriguing is that, well, if there's one defective product out and they mass produce this, it could lead to a class action suit with a lot of financial ramifications for the manufacturer and the seller. They're both liable. So it might not, Walmart might not have manufactured these goods, but because they're selling them, they're on the hook. Everyone in the stream of commerce is on the hook because we're trying to protect consumers. So you sue. That's why you often see these lawsuits with these large captions about number of defendants, because I sue the manufacturer, the Toshiba blender company, but I'm also going to sell Walmart because they were the ones that sell it. I might even sell one of the sub-manufacturers that supplied the blades that went in the machine if that's what I think is defective. So everyone in the chain of commerce, if you will, are potentially on the hook for it. And what do you buy? That's why these companies buy a great deal of insurance, and that's also why they buy what? because they're fearful of liability. That's why a lot of people think lawsuits are out of hand. We got to curb lawsuits. We got to stop it so business can do business without being in fear. But think about it. If businesses know they might be sued, what will they make in terms of their product? A safer product. So it cuts both ways that lawsuits actually might well help society, that safer cars, safer products, safer pills, safer drugs, all these things are potentially there because of fear of lawsuits. I'd make that argument. So anyways, you don't have to be in breach of contract anymore. So say I bought a product and I'm going to have my employees use it. In the old days, the employee couldn't sue the manufacturer if they got injured using a dangerous product because they weren't in what we call privy of contract. Privy of contract is dead. If everyone only could sue in privy of contract, employees wouldn't be able to sue in products they're using that were supplied by the employer. Now it's basically, if there's a reasonable foreseeable expectation of use by third parties, those third parties can sue for product liability. And all product liability is a certain product is defectively either designed or manufactured and injury to property or persons happens, so you can sue over that. And then the Magnuson-Moss Act, this is a big one. All warranties of consumers' goods have to meet certain requirements. There's this clear disclosure of all warranty provisions, all the legal remedies available for the consumer. And according to the Act, a consumer must be informed of the warranty prior to sale, can't become after, like what the limitations are. And then if the product costs more than $15, they have to either repair or replace within a reasonable period of time. I think it's a good law. It helps the consumers. I'm a consumer, you're a consumer, and it's just reasonable that manufacturers of goods and sellers of goods have to basically not supply junk. And if they do, they have to make us whole. That's really the bottom line about warranty law. Nature, cause of harm. We do know that a lot of sellers of goods do put on something called they limit their warranty that no consequential damages. And you should know what a consequential damage is. Say I'm a manufacturer of cars and I'm buying ball bearings from a ball bearing company. I'm going to put those ball bearings in somewhere in the engine. I'm not a tech guy, so I don't know what I'm talking about. But basically, if those ball bearings are defective, my car will be defective and I'll be out maybe millions of dollars of profit and employment and all kinds of things, even though the contract for the ball bearings might have been for $100,000. So I'm not suing them for $100,000. I might be suing them for millions of dollars because their product's defect, their breach of warranty, implied or overt, has caused me a loss of millions and millions of dollars. That's a consequential damage. Most manufacturers of goods hire decent lawyers, and the decent lawyers always say, we're only responsible for the direct loss you suffer, not consequential ones. Your direct loss is you're out $100,000 of ball bearings, not the millions and millions of dollars of profit and or gross income that your company would have made if they could have used the ball bearings. And then the Consumer Protection Product Safety, we know both on the state level and the federal level, there's the Product Safety Commission. They have a right to recall goods without a hearing. If they find an inherently dangerous product, whether it's a pill for diet stuff, whether it's a medication for your eye, it turns out to make you blind after you put it in there. If it's like a product I had at one time, Super Soaker rocket thing, you used to pump it up and then you press the thing and the rocket would shoot, 300 feet in the air and go quite high. But the thing shot off so fast that even though they were foam little blades on the bottom of those foam little blades would cut kids' face. So we got this recall. Instantly, we're supposed to give up that product and the seller could no longer sell those. And they had to give us either money or give us an alternative product. It was our choice. It was the consumer's choice. Product safety. I think we want these commissions out there. Now, the thing is, if I'm a manufacturer of goods and I think my goods are safe and appropriate, I'm entitled to a hearing, but the hearing's after the fact. We're not going to let dangerous products still be disseminated out in the community if it's making people blind or maiming them or hurting them. The government can pull it off. The Consumer Protection Safety Commission can pull the products off the market immediately, subject to a hearing later on. And if it turns out they acted too rashly or too inappropriately, you'll win the day, and you might actually get damages from the government because it's a taking without just cause. It's rare. Usually when the Consumer Product Safety Commission is getting involved, your product has some problems. And it might be, and usually after a certain amount of warning. So one I most recently read about was I think it's the Sunbeam slow cooker. I think it's slow cooker. It might have been a pressure cooker. I'm not sure which, but something to do with the lid coming ajar and causing severe burns, over 100 complaints. So those were being recalled. It's for the protection of the consumer. It's actually, in some ways, if you think about it, a protection for the manufacturer, because if the products are recalled, they can either repair them so they're now safe to use, or they can avoid further maiming people and be subject to very major lawsuits that are out there. I remember for a while, it was it's got to be the early 1990s. I was in a competition with another, actually, he might be an instructor of somebody who teaches at the Mountain, stayed friends all these years. He's a lawyer. We were competing about a weight loss, and there was a medication, I think it was called Thin or something like that. And it was kind of, you just take this thing, it suppresses your appetite, you shed pounds like you wouldn't believe. I never take something like that. I'm just not a big believer in that kind of stuff, old fashioned. I'd rather fail than kind of pop pills. And so did my friend. He didn't do it either. But I remember this cop, because we're in court all the time, the cop was saying, "Hey, you got to try this Fin. I have funny, I lost like 80 pounds really fast. It was great." Well, then it turned out that it was causing significant heart valve problems in a significant number of people, not just in a few, like a lot. And that drug you don't even hear about anymore, although it help you lose weight, it also help you lose your life. And that's why we have things like the Consumer and the Food and Drug Administration acts as an arm of the consumer protection agencies, because they don't want unsafe food, pills, drugs, tools, equipment. All those things need to be safe in some fashion. Truth in advertising, that's the big one. Remember I talked about before, you can advertise a price to the general public, and then when they come in, well, that's not the real price. We just want to get you here to negotiate. The real price is this. This is where if you violate this area of law, you'll get punished. So that's why very few sellers of goods violate truth in advertising. Product uniformity, that's pretty straightforward. Usury laws, this is real basic. If you're going to have interest charged, and a lot of people can't afford to buy a new refrigerator today, so they buy it on credit. And they say, okay, I'll buy it from Lowe's, and Lowe's will finance it. And Lowe's is going to say, okay, the price of the refrigerator is $1,500. I don't know what a refrigerator costs. I'm assuming they're like that. $1,500, and you're going to pay us so much a month with 20% interest. Is there anything wrong with that? Well, 20% interest is a hell of a lot of interest, but is it illegal? There's three different kinds of interest rates that can be charged. There's the contract rate. In that example, it's 20%. There's the legal rate, where there's an expectation that interest would accrue, but the parties haven't articulated it overtly. And each state has different legal rates. Massachusetts is 12, for example. So if interest is accruing and no one put down the amount there was, the law will automatically apply a 12% interest rate. It's pretty significant. The next one is the maximum rate. And I don't know what it is in each jurisdiction, but generally speaking, it's somewhere around 33% per annum. You can't, if you start charging more than that, it's considered usury, meaning that it's over the maximum rate. What does it mean if it's over the maximum rate? It's illegal. So what happens? If it's an illegal interest rate, does that mean the whole contract's null and void? Usually no. It usually means we're going to drop it down to the maximum rate. But if it's such an abusive rate, like loan sharking, it actually might be a crime, because you're charging so much interest that it's almost immoral. It's unconscionable. The usury rate's so high that you're really loan sharking. And so therefore that contract might be a null and void. And you wouldn't even be able to get your principal back because you were charging such an outrageous amount. It's very rare. Most circumstances, if it's a usury rate above the maximum, you drop it down the maximum. Sometimes if the conduct is fairly egregious in how much was being charged, they drop it down to the legal rate, or they drop it down to zero, and all you're entitled to get back is your principal. It's a hodgepodge of rulings that come down when somebody's charging a usury rate. So that's why you never want to go above the maximum, because you could potentially lose even your principal, but more likely you'll drop down to the legal rate or no interest at all, and then you'd be really sorry about it. Truth in lending is in the book too. This is a good consumer protection. If you ever take out a loan or credit for the purpose of buying either a home, although it's not about home in this chapter, it does relate to it though. But you're buying stove, you're buying an oven, you're buying a couch, you're buying furniture. We all do it, and we do it on credit. We either get store credit or we do it on a credit card. There's a truth in lending statement that has to come out. You have to be told the interest rate, how much you'll actually pay back the debtor or the creditor. You're the debtor. Like you'll have so many months of payment. This is the total you'll pay back in principal. This is the total payback in interest. This is when the first payment is due, and whether or not you can pay it off early. Say I have a 5-year loan on a car. Can I pay it off early without incurring the interest? Can I waive off the interest if I pay it early, or is the interest going to accrue for the whole 5 years, even though I want to pay it off today because I've got some money I can lump sum? That all has to be disclosed to you. And what the goal is by disclosing everything clearly, overtly, without any misconception, consumers know what they're getting into. And I've had it happen in real estate before. I'm doing a closing. I got the truth in lending statement out, and clients are like, "Oh, I'm so happy. My mortgage is going to be, $800 or something." And I'm like, goes, "Well, yeah, but don't forget you have to pay interest on the loan, and then there's other things that are amortized in it, that things like insurance and PMI maybe. I don't want to get into all that, but basically through that document, they start to say, "Whoa, I'm actually paying a lot more than I thought," and that allows them 72 hours to walk away from the obligation they agreed to be in, because we don't want consumers to be rushed into having consumer debt that they find very difficult or not patable. It's not compatible with their ability to pay. So you have a 72-hour right of rescission when it comes to consumer financing of goods from merchants. I think it's a good rule. And then the last one, well, the fair debt reporting. If your credit reports are false, there's false information, there's an obligation to correct them and to supply you, where does it come from? If you ever denied credit, you have the right to know why you got denied credit and from what source, and then you can look into it and make any corrections. And they have to do due diligence and repair those reports if they tend to be faulty. The one I do want to talk about is this one right here: statutes prohibiting unconscionable contracts. I have dreams about having a sailboat someday. I always wanted to name it the unconscionable. It sounds good, but it's actually a terrible term. Unconscionable just means that it shocks the conscience. If the terms are so harsh, so fundamentally lopsided from one side or the other. Remember we talked about that before? Do we care about disparities in value being exchanged between the parties, the value of consideration? Generally, we don't. But every so often, the law does provide sort of a wild card, a thing in equity, where we just don't want people to be so abused that it shocks the conscience. So that's an argument that's sometimes made. If the terms and the benefits flowing to one side are massive and the detriment and the harm is flowing so significantly to the other that it almost looks fraudulent, we're going to allow them to raise the argument of unconscionability. Doesn't work very often. It has to be just that. Oh my God, I can't believe you have to pay this much for that service or these duties. Or I think it was I don't know if it was my brother or my sister bought a subscription to something. It was a music one back in the day where you get albums sent to your house, and she has some outrageous. Initially, it was really low to sucker you in, but then she was paying. I mean, this is back in the 70s. She was paying like huge money each and every month. And if she didn't outline the records that she wanted in a timely fashion, they would just send her whatever records that they thought was in her genre of liking. Just send her all kinds of crazy stuff. And I remember my father, basically trying to cancel the contract over the phone. My father was kind of at it. And he didn't use the word unconscionable, never got the litigation. They allowed him to cancel because my sister at the time was under the age of 18. So it was a what? Yes, it was a contract subject to avoidance, although my father didn't know enough about the law at the time, and we didn't have a lawyer in the family, that he actually could have got all the money back. And my sister would simply have to return the records if they were still in her possession. We'd have to return it, and she can get all the money back. But we just stopped to credit the contract at that point. I just remember my sister being really upset over it because she loved their music. But unconscionability is that wild card you throw out there. But we had the avoidability because she was a minor. It was a minor contracts, and it wasn't for necessity. Music was a necessity. But what could say it happened today? It was one of my kids that did something nutty like that. Well, if it's one of my kids, I get him out of it based upon a minor's contract. But what if it was an adult child? I have a child that's right below my room and he's about to play guitar. I can sense it because I heard the amp pop a second ago. If he went and bought something and I thought it was very, very unfair, the nature of the contract, and it was very unwise and very, basically he was getting ripped off, and I couldn't raise the fact that he's under the age of 18 because he's 20, what could I raise? I guess I can raise insanity. He's not competent, but that's not going to work. He's competent. What might work is unconscionability, but it has to shock the conscience. Pretty rare. And that's, I think, mostly what I wanted to get out of Chapter 18. They have state and federal consumer protection laws. And that's Chapter 19 in a nutshell. Very important chapter. Be well, everyone.